The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on cable channel 15 in Greater Des Moines, Iowa. The program is aired on Sunday afternoon at 1 o'clock. The program is again repeated on Wednesday evening for people that don't get an opportunity to see it on Sunday, or vice versa. On Wednesday evening, it's aired at 9:30. Also, this program is aired in Council Bluffs every other Thursday at 4:30 p.m. You can see it out there on Cox Channel 23. You can email us at vocaliowa@mchsi.com or give us a call. Parents that need some help out there, we try to help you on a one-to-one basis. We understand your struggle out there when you lose your children to the DHS. My number is area code 515 here in Des Moines, 276-3956. And John's number is area code 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa, and we intend to influence public policy as it has to do with child protection issues. We do that by a number of ways, not the least of which is to get on each week onto this program talking about those child protection issues and the attendant issues. One of the most interesting attendant issue is called the judiciary, and so we've invited several times during this past, in fact, a long-term guest, I guess we call him, Terrance Walker, to talk to us a little bit about some of these judicial issues. Before we turn to Terrance, let's talk just a little bit about some of the cleanup work that we should have plugged into previous programs, but it has to do with getting your name stricken from the child abuse registry. There is no reason to have your name on a false child abuse report placed on the registry. There are statutory reasons why and influential reasons why the department would like to have your name splashed all over, because they don't mind having 49,000 cases on the child abuse registry. It gives them reason to expand, to have larger staffs, to have greater and greater influence. And they really don't care whether you're guilty or not. And time is always on their side. Well, we've mentioned forms that you need to look into, and we'll show those. I don't think we have those forms right in front of us today, but in order to, yeah, we have one of them. In order to get to those due process concerns, you'll need to go into an appeal process, and of course they introduce a whole lot, a whole number of new terms. If you go into the website called dhs.state.ia.us, you'll find an appeal section. In that appeal section, you will find this form, and this form gives you an opportunity. Once you get a copy of your child abuse report, gives you an opportunity within the 6 months following that report to resist the report, to show where they have gone wrong in putting that report together. If you look at the background information that you'll find on that same website, you'll find out how they are supposed to assemble the report. And the way they assemble the report is that they, first of all, they try to visit the child as soon as possible. If it is an emergency situation where the child is in imminent danger, they are required to visit the child within 1 hour. That seldom ever happens, but that's the rules. They're supposed to visit within 1 hour. In other cases, they're supposed to visit within 24 hours. And you had a comment, Don.
Some reasons why they don't always get to, the worker doesn't come out to the home within 1 hour, as you was talking about.
Yes.
We've heard of cases where the telephone rings at the social worker's office from a doctor, and we have found that when a call comes from the doctor, they'll jump to that call and go out and interview the family out there. And we have heard where children get injured as a result of those calls, and then the social worker doesn't get to the scheduled one that you were talking about within the hour that they are supposed to do once a month. And in this one case I'm thinking of here in Des Moines, the child died. The DHS worker wasn't paying attention to their regular schedule, and supposedly you trust your doctor. The doctor calls without the parent knowing that the doctor was squealing on the parent, or on the parent and the child, and there was nothing to complain about. In fact, it was the doctor that injured the child. Wasn't that interesting, John?
By all means. There are two brands of reporters here. One is called a mandatory reporter, and that's made up of almost every professional group that has anything to do with children. In fact, at one point I thought they were going to make everybody mandatory reporters. In Florida, everybody is a mandatory reporter. I thought they were going to expand it here in Iowa to include assistant garbage collectors and so forth. They haven't gone quite that distance yet. They do add new people all the time. One year they added priests and ministers and so forth in churches as mandatory reporters, which I think is ridiculous and is far outside of their jurisdiction to rule who reports in the church and who doesn't. I think that is something that the church fathers need to have some control over. But the state legislature mandated it, so now it becomes law that even priests and ministers, youth directors and so forth, choir directors and so forth, have to report child abuse if they have a reasonable belief that abuse has occurred. Well, that's one major segment of the population. The other major segment of the population is what they call permissive reporters. That means you can report if you want to, and like you say, Don, they may pay more attention to a mandatory report than they would a permissive report. A mandatory report carries a little more weight simply because mandatory reporters know a little more about how to report. That is, how to distinguish what is to be reported and what is not to be reported. A permissive reporter might report dog bites child. Well, see, that's not child abuse. It's unfortunate, and it may be not a good thing for children, but it's not child abuse. A mandatory reporter would know that that is not child abuse and wouldn't bother to even report it. So the ones that come from mandatory reporters should have a little more credibility than those from permissive reporters. Permissive reporters are really a neat idea because permissive reporters, and they tell me from listening to the conferences and so forth, that these are usually drunks after parties at night, and they get on the phone, and sometimes they're even coherent enough to understand what they're talking about. Well, if out of a confused telephone message they can pick up the name of a child and the school that that child goes to. Boom, they have a case to investigate, even though it may be 45 miles away. Who really cares? With fuel prices at 2.65 a gallon, just jump in a car and take off and investigate. Well, in that investigation, they may go to the school. If they cannot reach the child at home, or if they are denied access in a home, which they should be, then they can go to the school. And they find the school sometimes far more convenient than driving to the farm home. You know, who wants to drive 45 miles and then have to go up a 3/4 of a mile lane to investigate child abuse, only to find that the people aren't home? But they can count on the children being at school, and if there's 3 or 4 children involved, they can talk to all the children from one location. So they call that confidential access, and one of the things people ask me, can they do that? And the law does permit them to have confidential access if they have permission from their supervisor. Well, how do you know they got permission from their supervisor? And what supervisor wouldn't lie when confronted with the question, were you consulted regarding confidential access before you sent your dogs out there to the school to do this investigation? Well, that's the way the investigation starts off. And they're supposed to talk to all people who, well, first of all, they have to talk to all the children in the household. And I don't know why that is absolutely necessary, but they might be able to find more than one child in the household who's been abused. So they can write up more and more and more reports. And first thing you know, this family may have 3 or 4 reports stacked up. You have 6 months after you get a report in order to appeal that report. And that report can actually be appealed starting off with this document we showed you just a moment ago. And that can be found on the DHS website. And in this case, you would mark it other because this is a standardized form that covers about everything. In this case, it doesn't have child abuse. It has family investment programs and Medicaid or waiver, state supplementary insurance and child support, adoption, and so forth. But yours would be other, and you'd explain that you have a report, assessment, they call it, of child abuse, which names you as the perpetrator of child abuse. You need to immediately, once you get notification that they're investigating, you need to immediately get a copy of the full assessment and look it over. That assessment should be an accumulation of all of the facts that they have gathered in pursuit of this particular investigation. And once they have assembled the facts, then they can look at those facts to see if by chance there is a greater degree of credibility for the facts that have been raised in the case, or if they're if there is very definitely go ahead. If there is what they do is they weigh the facts, whether the child has been abused or whether the child has not been abused. If the facts show one scintilla of evidence weighing in favor of abuse, then they can say that there is substantial evidence weighing in favor of the abuse, and they'll found the report. And for the in most cases, they will put that report on the registry. The last count on the registry we found was 49,000 cases of child abuse on the registry. I think if someone ever went through and found out what these cases were all about, found out that most of them are false allegations, or very poor um, investigations, such as one I found where a social worker had gone to an elementary school when she got um, a tip that a child had been abused. A kindergartner had been abused at the home of his babysitter. She strapped him in a high chair. Now, wouldn't that be terrible to strap a child in a high chair? Well, you see, that's restraining a child to the worker who hadn't even taken any training for child abuse, but she was able to go to the school and get not only that one, but she was able to get 4 others simply by talking to the children. She could have got a 6th one, but the child didn't wasn't able to tell her parents' names or addresses. Thankfully, those parents were saved by the fact that they didn't teach their daughter what her address was. They just sent her to school to learn, not to be investigated. Well, once you get that report, you need to ask for a copy of the report. Scan the report very carefully to see what facts they are listing, and then determine how you would like to defend yourself from each of the facts that they lay down. I heard of one woman who took an abuse report like this, and they were talking about all of her relatives and neighbors and everyone else who said that she was an abuser. She cut up the report and or made copies of it first, and then cut up the copies and sent them to the people to determine whether or not they had actually made the statements that they were said to have made. I think this was down in Mahaska County. And come to find out, none of the people that were quoted accurately, and in some cases they were completely off. So this is one way you can prove that the report is totally invalid. There's a number of things that you need to talk about, and you need to talk to someone who's been there first, and we're only too happy to share whatever information we can. We're not attorneys, so we cannot give you legal advice, and we're not going to give you any illegal advice as well. But we'll give you some. We'll certainly give you some hints that may wind up helping you in the end to get that into an evidentiary hearing. They add a lot of extra terms. Evidentiary hearing simply means a hearing of all of the facts. It means you get your day in court, and that is part of the due process that we enjoy in America.
Does it cost a parent to go through that?
It costs the parents zero, unless you count out the work time that you lose for fighting the case, and the travel time and the cost of traveling back and forth. But you don't have to pay any fees for this part of it. This is the first time and the last time that you get to gather the evidence. You can subpoena witnesses. You can get statements. One thing that is a good idea, if you have 18 people who can tell about your relationship with your children and put it in an affidavit form signed before a notary, it's good to have that kind of information in the record. That way, you can raise your credibility much higher than the state, because the state only has one person in there to make all these complaints. You can have 18 or whatever you want. Then I would do that even with people that you intend to call to the hearing, to the evidentiary hearing, because some people cannot, at the last minute, may not be able to make it to the evidentiary hearing. You still have their statement, their notarized statement. If you can get them into the hearing process, then they can be cross-examined by others. It's an uphill battle, but it's well worth your time and effort to take these matters very seriously and dispose of them as soon as you can. Now, once you get the through the evidentiary hearing, you will get something called a proposed decision. written by an administrative law judge. That decision, if it doesn't favor you, can be appealed within 10 days to the Director of Human Services. Doesn't make much sense to me to appeal something to the director of the department that created the document in the first place, but that's the law. And we'll probably, if we talk to you, we'll probably straight out tell you what the law is as we know it. And by the way, that isn't practicing law. That's simply showing you what you should know and what we should know. Because if we are not capable of knowing the law, we can't be compelled to obey it. So there's no practice of law here. And we get blamed for practicing law without a license every once in a while. I got one of those warnings in court just recently from a judge who doesn't know how to practice law. And she was, we have so many women judges in our Polk County Court. She was saying that perhaps she should report it to the Iowa Supreme Court. Perhaps I should report her to the Iowa Supreme Court and take the burden of that referral off her shoulders and let the court know just where this woman stands with respect to the law. I think that we'll probably ask Terrance about judges that have no respect for the rule of law. Where should those judges be? Well, Don, you had a comment.
Yes, you were talking about the evidentiary hearing. The system, DHS, and the administrative people encourage you to have a telephone conference. And John was talking about you bringing witnesses. But they encourage you to have a telephone conference. That's very nice because you don't have to take off a whole day to do an hour of telephone conference. But we discourage that because if you have any concern over the abuse report itself, you need to go in person and argue your case. Secondly, pertaining to the getting the form, John was saying you get it off the internet. But for the people that do not have the internet that's watching this program, they can talk to their social worker or they just walk into the DHS office and they will have the form there and you can make that request for it. John?
Okay, I'm glad you picked up those. You can get the form off the internet, or you can get the form from the local DHS office and mail it in by snail mail. I think I would. You usually get a very prompt reply. If you don't get a reply to your email request, then you need to contact them immediately, because they like to play games with this time rule. They say, well, you didn't get it in within 6 months. Well, sorry about that, but quite often they are dead wrong.
So you should get a response in just a few days from them. And if you don't receive a response, they haven't got it. And you can also hand deliver this to the Hoover Building for the people that live around this area. John?
By the way, we have also one pet rule around here too. Anytime you file something with the DHS or any of these agencies where you're demanding discovery information or anything, it's a good idea to make 2 copies of that, go into the counter, and have them stamp both copies so that you have proof that you made the request or that you are fighting the paper or whatever. So that you have something in your record that shows that they got it.
What's that mean? Stamp? You say, John? Clarify that.
It would be a date stamp that they use they're known to use in their office.
So you come home with a date stamp on there, so you have the proof that you've been in there.
Now, one other way, if you don't go into the counter, and a lot of people who have to work for a living, don't have the time and can't go into the counter all the time. So you might want to keep this, in this case, 3 copies. Keep one of those copies at home. Send 2 of them with a self-addressed stamped envelope and ask that they return one of those copies to you. And if they don't do it within, say 5 days, then get a hold of them and
By telephone?
by one way or another, and
Or walk
find
in
out
in person?
find out why you didn't get your copy back when you furnished the postage paid envelope.
Now, they can get that file stamp also to the local DHS office if they take it back in there and drop it off.
Correct.
They'll stamp it there so you have your date there for proof. Okay, John?
It's important that you attend to some of these little details because you can spend an awful lot of time in evidentiary hearing and in subsequent court hearings arguing about little things of this sort, and you can embarrass the living daylights out of them if you say, Your Honor, I have a document here I'd like to introduce into evidence. This is the document that was entered on April the 7th, 2006, that the worker says was not received by DHS. Here is documentary proof that the worker happens to be wrong again. Well, there are a number of people who perform professional services, such as attorneys and others in the healthcare field, who should know a lot about child abuse. Kim Hart from Ohio, Holland, Ohio, sets up a conference every year in Las Vegas. One year is held in Kansas City, so a lot of Des Moines people had the opportunity to go to that conference. This conference is an assembly of a lot of high-grade, highly knowledgeable individuals in the business of law, in the business of practice, in the healthcare fields for children and so forth. Her program this time is called Science versus Junk Science in the Courtroom. You suppose they try to use junk science in our courtrooms? You bet they do.
What's junk science, John?
Junk science simply says this is something that we're going to use to baffle people, making them think that it's real science when indeed there is no scientific basis whatsoever in the premises that they're using and calling junk science. If you'd like to talk to Kim Hart, here's one place where you can email her, Kim A. Hart at AOL.com, because you might like to attend that conference in Las Vegas in September. Let's see, it's September the 28th through the 30th.
Oh, it's my birthday.
Is that right? All 3 days?
Not unless well, my mother would have to have a heck of a labor.
You bet.
But no.
That'd be a good birthday
day.
gift for somebody to say, here's a few $100. Why don't you just take off and go to Las Vegas? And if you can't find anything else there exciting in Las Vegas, attend this conference of Kim Hart's.
Well, you better swing the camera over on the birthday boy.
There he is.
My birthday, yeah.
Oh, okay.
That's September.
Coming up, though, very fast. September.
You bet.
It's going pretty fast, to tell you, the year is.
Yeah. Time is moving so fast, and I notice the older I get, the faster it seems to move. Don is going to be reading from a book later on in this program that is published by Richard and Lillian Dunsmore of Coatesville, Pennsylvania. The name of the book is The Shredding of Families. The Shredding of Families. They're from Coatesville, Pennsylvania. And the last time I heard from Coatesville was when my family and I were very near Coatesville at a campgrounds. And my young son, young sons seem to wander around the place and get into mischief at times. Well, this fellow was usually pretty fleet of foot, but this time he tripped over a tent stake that was made out of heavy metal. And the metal didn't give away, but his ankle did. And so we had to take him to a hospital in Coatesville, Pennsylvania. So I mentioned that to Lillian and Richard when I saw them at a conference last time. And they said, yeah, we live right adjoining the hospital grounds in Coatesville. Well, Coatesville is a very pretty territory. My son is now much older than he was then. I hope he doesn't still trip over tent stakes, but he's in the real estate business. I knew he was destined to be a good, honest real estate man when he was with me and we were trying to sell a house, and we sold it on our own. He would wander around through the rooms with me and the prospective family, and I'd say, look at that beautiful, expansive backyard. We enjoy that a lot. Well, my real estate son says, oh, but it's hard to mow. It's steep and it's hard to mow. Then I said, as we went into the bathroom, I said, I've changed all the leaky faucets in here. I've installed all new ones. He quickly said, but they still leak.
Ah.
So I thought, now this is a man that is really going to be good to be a real estate man. So right now I think he's selling real estate in Johnston, Iowa. Well, a patient at Coatesville, Pennsylvania at one time, a real estate man in Johnston, Iowa now. We need to turn over to talk to Terrance Walker. I think before we do that, we'll show some of the judges, because there's some judges that we believe should be considered again for re-election to office. We cannot elect them to office, but we can throw them out with our vote. And in this case, in District 5A, there are some in the adjoining counties: Virginia Cobb, Richard Clogg, Thomas Mott, and Kevin Parker would like to be retained in their judgeships. If you believe that you know enough about these judges to rehire them at their enormous pay, you should vote for these people. If not, you should vote against them. I don't think it behooves you to know just how evil they are. If you don't have enough information to show that these are good people, you should not vote to have them in. Simply vote no. And some people have told me that when it comes to judges, they simply say no to all of them, because sooner or later, one of these judges is going to get caught up, and the public is going to say, no, no, no. You're not going back to office with your attitude, with your inabilities. You're not going to go to office. Here are some that are closer to home: Eliza Overham, Donna Paulson, Artis Reese, Carol Egley, Carol Coppola, William Price, Louise Jacobs, and those are 5th District judges that are coming up for retention. They'd like to keep their jobs, so and they need your yes vote in order to keep their jobs. But you have the final say. In this case, you're the boss. You can tell whether or not these people will have rule over you. Okay, with that in mind, let's go to a fellow who heads an organization called Vote Iowa Judges Out. Heading that organization is Terrance Walker.
Well, thanks again, John. It was an eloquent presentation and an eloquent introduction as usual. Um, and yes, I am the self-proclaimed judge of the judges, and I'm gonna have to change up my verbiage here. I usually say no one can do it better. I think that you guys out there can do it better. But the problem is that we don't get enough information about the judges. I think there's some interesting changes going on in that light in different areas of the country. Like North Carolina had instituted a, um, a system whereby the judges were actually given informative uh, profile information online, so that people can have some inkling of what the judges are, a little bit about the judges. I thought that the Des Moines Register has done a great job. Just as of recently, yesterday they had an article on Judge Novak. Now, might recall Judge Novak might not have had too much good things saying about the way he conducts his proceedings. Matter of fact, he not only has he been involved with with some incidents which I feel were kind of questionable, to say the least. He was involved in a case involving John Harvey, which I felt that he blatantly misstated the facts to go ahead and to resolve the matter in favor of the state in the first instance. But lo and behold, truth and justice did prevail, and John Harvey was cleared of any wrongdoing in the case that was before Judge Novak. Interesting article, though. If you have a chance to check out the Des Moines Register's website, or get a back issue of the April 11th edition, you'll find an interesting article on Judge Novak. And I usually call him Racetrack Novak because I did see him at the racetrack one time. And I've heard that he's a very skilled, or not skilled, I should say, but very avid bettor out at the racetrack. So, but the article yesterday actually displayed him in a different light. Um, Judge Novak was displayed marrying people, and they showed that he did that regularly. So, I mean, I guess that's one aspect of Judge Novak that, is good to know about. So, Judge Racetrack Novak, I guess he must be a little bit on the right track sometimes, but obviously he wasn't on the right track in the case involving you, John Harvey. Did you have some comments on that?
Should we retain individuals who misrepresent the facts in court, who do not make their decisions based upon the relevant, credible information, but base their information on some other outside source?
Well, I feel that we shouldn't, because I think that, to me, is the height of, or the epitome of injustice, when you go into a courtroom and a judge either is very careless in stating the facts, or, at worst, is blatantly misstating the facts. I think that, in all fairness to Judge Novak, I mean, he was given ample opportunity to get the facts straight, which were continually presented to you in multiple pleadings, multiple filings that you made to that court. I don't know if he didn't take the time to review the filings, or if he just rubber stamped them, or what, but it just appeared to me that the issue that was continually brought to light by you in those pleadings, which was that the deputy who falsely arrested you for having a camera in the courtroom, or in the courthouse, which you were licensed to do, I feel that he blatantly misstated the facts in stating that the officer signed the affidavit under oath, because anybody with any 2 cents of legal knowledge, or even without legal knowledge, would have known that, hey, this is not an oath. If somebody signs something, it's not an oath. It's not an oath unless you have an officer present that's authorized to administer oaths, and that oath appears on that document. And this is the actual Iowa code definition and the Iowa case law definition. So I think that he did blatantly misstate the facts on that one. And, you know, albeit he might be a good guy in some aspects and marrying people and doing things of that nature, I think that what he represents is the height of injustice in the court system. And there's an attorney, matter of fact, next week we're going to be presenting the interview with an attorney out of Las Vegas named James Ray, this individual right here. He says that the United States Supreme Court should recognize that judgments that are made by courts that are in which they blatantly misstate the facts should be void or avoided. And we'll be talking to him some more about that, but he's also challenging the whole issue of judicial immunity. So we'll see what he has to say next week, because he did file a petition, which is on the next page here. We have the cover of it. He filed a petition challenging not only the validity of judgments, but he also challenged the whole idea of judicial immunity. In this case, he just filed 05-1197. If you want to look it up on the United States Supreme Court website, might have to do a search for it. I can't remember the actual domain name or the website address or whatnot, but I think it's www.ussupremecourt.gov or something to that effect. But very interesting, and this gentleman has done a lot of work on that. I actually read through most of it, not all of it. There's about 119 pages on the appendix, and it's about 24 pages long for the petition for writ of certiorari, which they call the documents that you have to file in the United States Supreme Court when you want to challenge something. But I think that's it for this week. I'll leave the balance of the show for you guys if you have any comments on that.
Going back to the Novak case, one of the things I think that was very striking in Novak's ruling, I had filed a very extensive set of objections before trial, and asked for his ruling point by point. Well, he didn't address all the points, which is not all that bad, because you don't expect them to do things totally correct, do you? So, but what happened in some of the arguments that the judge gave, the arguments were not found in the record. Now, what do you do with a judge, Terrance, who makes decisions based upon information to which he has no access? Now, who had access to the information that he put in his ruling? The only one that had notable access to that information was the prosecutor. Now, it appears, although we may not ever be able to prove it, that the prosecutor actually wrote the ruling for the judge to sign. I think it would behoove the judge to look over his ruling and see if he can find evidence in the record that he had before him, evidence that he could cite from the record. Now, our courthouses are called courts of record, and there is a reason for that. That is, everything that is said and done in the courthouse is supposed to be written down. That way, when you make an appeal, you can go back to the record to see what was established before. Well, if you're going to destroy that record or if you're going to corrupt it in any way, then I think you've got some real problems. And I think Judge Novak engaged in corruption of the record when he accepted information from the prosecutor in order to prepare his ruling. I don't think he had any right to any information that the prosecutor had or information that the prosecutor thought about regarding that matter. And I think I can prove it from the ruling itself, because I think the ruling speaks for itself. The absence of the evidence will also speak for itself. Terrance?
Yeah, and I think I can't. I have to second your emotion on that. I can't really um, articulate it better, or maybe I can. I just wanted to summarize what I think would be best done. Um, I think that if Racetrack Novak was truly to get on the right track, instead of marrying people, he needs to marry the truth with the law. Therefore, we would have justice in our courts.
Okay. Okay. Uh, an interesting concept. By the way, did you know their Marion fees went up? That doubled from $100 to $200.
Well, they got to
So,
probably pay them pay
so
raises.
he'll have more loot to take to the racetrack now.
Oh,
Okay.
well, I might need to get in that business, I tell you.
You bet. Don, we're going to turn to you in just a moment because you've selected some stories from a book called Shredding of Families, written by Richard and Lillian Dunsmore. Let me tell you just a moment about this couple. This is a professional couple. That is both of them are retired from professions in the medical world. Um, I forget what positions they both held, but they're very knowledgeable about child abuse situations, and so they consult from time to time. They're getting up in years now, so they do more writing than consulting. But let's turn now to Don Burgmaier to read a book written in Coatesville, Pennsylvania by the Dunsmores. Don?
Thank you, John. I'm going to read a little bit out of the first part of the book where they talk in general about social workers, and then I'm going to turn to a short story about what actually happened to a family. CYF tactics. Blemishes already perpetrated include the development of Gestapo-like tactics. Gestapo, that comes from Hitler's time, Germany. Wherein children are snatched, this is what the system is doing, are snatched from families, often taken from schools, often without prior notification or hearing. Many of these children, saved by the, and I'm going to change the term to DHS because they're talking about New York, which uses the term CYF. DHS are transplanted to foster facilities many miles away from their homes, families, and friends. Such facilities should be labeled concentration camps, possessing primitive living conditions. Children are poorly supervised, poorly educated. Medical and dental care are substandard, and nutrition is deficient. They are brainwashed. Yes, your children are brainwashed, all right. Exposed to foul language, introduced to pornography, the very thing that the DHS says they're trying to stop. Cigarettes and drugs. Children are punished or threatened if they object or attempt to avoid the improper activities that are foisted upon them. Can you imagine being in the children's situation and this is forced on them by the DHS worker? A lot of people say, oh, that's not happening. You're fortunate if it hasn't happened to you and your children. It goes on. Children are instructed to report their parents or grandparents of any act to discipline them. And that can happen in the school, too. They tattle on their parents, so to speak. Uh, it is now commonplace for children remaining at home to threaten their families with DHS intervention upon the slightest correction of bad behavior. Children are encouraged to spy upon their parents and grandparents and report all activities to DHS and the psychologist involved. The average caseworker may or may not have a bachelor's degree, may be unmarried, and if married, may have no children. Yet they persist in polyparroting their limited skills. They presume to know more than the parents who have years of parenting skills and or advanced educational degrees. They insist on parenting classes that are poorly supervised and improperly conducted. Although poorly trained, unlicensed, and inadequately supervised, they blithely continue their blundering ways, enslaving children, destroying families, as well as financially bankrupting them. If you haven't been involved with the DHS, I imagine you're having a hard time comprehending that our government is doing that to families. I'm going to jump over here to a short case. The time is getting away here. But I hope to conclude it before our time is up. Case 4 in this book. I don't want you seeing that bum, screamed Kleinman at his 15-year-old daughter. All reasoning had failed to show the child that her current boyfriend was a drug addict and a thief. So now we're switching to a point where the father is trying to take care of his daughter, a 15-year-old daughter, and meet her needs, and she's got a boyfriend. And the father is trying to get across to her that that's a poor boyfriend to have. So it continues. Parental warnings failed and confrontations followed. Cheryl's intransigent attitude continued. Her willingness surfaced after a blistering confrontation with her father. She reported him to DHS for sexually molesting her. Isn't that interesting how it changes from the father just saying, you shouldn't be going with that type of a boyfriend. She reports it as sexual abuse. Many schools teach the children how and when to call DHS, supplying local phone numbers. Within 24 hours, Kleinman found himself in the county prison. The community was shocked. Here was a stolid pillar of society, a hard-working man accused of a horrendous crime. They were stunned. Kleinman was stunned. I'm sure the father was stunned. He's trying to do his best to protect his child. And what happens as a result of that? So many parents are out there trying to protect their child, and then the DHS gets involved. Legal aid was offered to him, and it was suggested that he plead guilty. Plead guilty to what? Sex abuse. That didn't have anything to do with him trying to persuade his daughter to stay away from the boyfriend, but that's what he was told to plead guilty to. And he wailed, "But I didn't do anything." 2 weeks later, Cheryl's boyfriend dropped her and sought more exciting territory. This is the daughter who had this boyfriend. He decided to go elsewhere. He'd had enough of this girl that was his girlfriend, and now he's moving on to somebody else, another girl to destroy. Crushed, she told her mother the truth. She didn't go to the father, but she did go to her mother and told her the truth. She made up the story about molestation just to get even with her father. Together, they approached DHS, who was not the least bit interested in this admission of fabrication. That's a typical DHS court system. When the child comes out and tells them the truth, no way, because it don't make any money for the DHS worker to hear the truth. Cheryl wrote to DHS and the judge admitting the falsehood and requested his release. At the court hearing, DHS and Kleinman's attorney approached Kleinman. If he would sign an admission of guilt and agree to enter the sex offenders program, you're hearing all about the sex offender program out there. How many innocent people are on that program? So if he would just enter that sex offender program, he would be released, a free man. Totally wrong. Anybody that's done that knows they're found guilty and live a lifetime of guilt when they didn't do anything in the first place. The father said, "But I didn't do anything. My daughter is here to say I didn't do anything to her. I will not confess something I didn't do." "Your Honor," injected the DHS worker, "if the prisoner will sign this form agreeing to counseling in our sex offenders program, we have no objection to his release." Mr. Well, why shouldn't they? Here's a sex abuser they're going to release to the public. Or is he a sex abuser? Just because the worker says he is, why would they be wanting to release a sex abuser to the public? Sometimes this gets funny. Mr. Kleinman will be asked to attend the program once a week at a cost of $40 a session. He will be required to attend until such time as the DHS deems he has rehabilitated. "I understand that's never," piped up Kleinman. "I hear you keep everyone coming until the money runs out, but you keep getting money. You get money from me. You get money from the government. That's all you care about. Money, money, money. No, I'll stay in jail." He folded his arms across his chest and jutted his chin in defiance. "Your Honor," said his attorney, "I have just learned that Mr. Kleinman has filed a suit against me and DHS in federal court. I can no longer represent him." Hey, Terrance, that's one way to get rid of an attorney, file an action against him. "I wish to recuse myself," the attorney said. His Honor cupped his chin in his hands, shook his head, and muttered, "Hearing postponed until next Tuesday." Kleinman, head held high, walking out to a waiting sheriff's van for yet another trip back to prison. This charade continued for another month. During this time, his wife was admitted to the hospital for surgery. His younger daughter, Kathy, was apprehended for ripping a gold chain from a classmate's neck. Finally worn down by the harassment from DHS and the district attorney's office and the added problems of his family, which he wasn't allowed to correct, you see, Kleinman finally plea bargained. He was now free to breathe the outside air, or so he thought, so he was told. Kleinman was immediately enrolled in the sex offender program at $40 a session. If he failed to discuss his crime in depth before the group, he was subjected to parole violation and would be sentenced to jail again. 2 weeks into the program, CFS or the DHS appeared at his door. He was told he had to move out. He could not stay with his wife and family. Reason, he might abuse his family. But he's never laid a hand on them. "You're all liars," said the caseworker. "Besides, we know that's best for all of you."
Thank you, Don, for that story, and we'll see you next